think you all deserve a break from me. So what I'll do now is I'll ask Paul Lander to come up to the lectern and just cover some key points with respect to estate planning. This topic is really important, and for many of you in the room, you've either addressed it, or I've nudged you, or I'm going to nudge you. So Paul is a person that does a lot of work with clients of mine to make sure we've got the whole picture covered if anything really bad happens.
I'm covering the topic which David mentioned earlier, which is estate planning considerations. And the first question to ask is, what is estate planning? It's a multitude of a whole lot of different factors that are taken into account. It is not just a will, which covers what's going to happen to your assets after you pass. It's not buying a funeral policy, but that may be part of it. It's also considering things like how you are going to be treated, both medically and from a financial perspective, if something happens to you before you die, where through circumstances beyond your control, you lose your ability to manage and control your financial and property affairs, or your medical affairs, which is obviously relevant to all of us at the end of the day. So an overview is, it is not just a will, it's not just dealing with your assets, it's a combination of that and a lot of other factors, including, and in particular, the importance of each one of us making decisions now, whilst we still have the capacity to do so, to deal with our affairs, financial, medical, and assets going forward. The primary consideration is assets, what happens when we die, and that's covered by a will. So hopefully all of us have got in place a properly drafted and up-to-date will, because even if you haven't got a will, the state government does impose a will on each one of us. And the imposition of that will may be a far cry from what each one of us wants to happen at the end of the day. It may fit, but it may not. And in most cases, it does not. So it is absolutely critical that you do have in place an up-to-date will which looks after things like, where do you want your assets to go when you die? Importantly, in a tax-effective manner, and very importantly as well, in an asset protection manner as well. There are so many horror stories out there, and I see it on a daily basis, with people with estates that are large estates, passing it to the next generation, and the next generation are involved in a multitude of problems, whether they are health, drug, alcohol, gambling, relationship situations. And what then happens is that from all of us as a parent's perspective, our fear is that the inheritance to the next generation, one, gets squandered, or secondly, disappears momentarily after a person dies in a family court or in a bankruptcy situation, or because of the person's having problems with drugs and related issues. And that can all be dealt with in a will. From a will's perspective, it is definitely not one size fits all. So although a will is substantially similar for all of us, it is unique also for all of us, because we've all got different circumstances, we've got different needs, and we've got different expectations and wants as far as our will is concerned. Principally, what does a will cover? It covers our assets when we die. And what are our assets? I think it's easier to say what are excluded assets. So certain things which are not covered by a will are jointly held assets. So if people own assets as joint tenants, for argument's sake, or joint bank accounts, or jointly held shares, that whole category of assets will automatically, and by virtue of the doctrine of survivorship, pass to the surviving spouse or the surviving person that's involved in that relationship. And a joint tenancy, for argument's sake, although it's normally between a husband and wife, it can be between family members as well, and is often the case that it may be between a parent and a child as well. So just bear that in mind. It does not cover trust assets. Many people have family trusts, so trust assets are separate from a will. It doesn't cover company assets. Companies like trusts would survive a person's passing. So again, although they're separate, they need to be dealt with and considered what's going to happen with that category of assets when a person dies. And in many cases, it doesn't cover life insurance and, very importantly, superannuation. It can cover superannuation if the nominated beneficiary is the legal personal representative of the deceased person or his or her estate. In that circumstances, the superannuation or the death benefits payable on a person's passing will go into the melting pot and be addressed as part of that person's estate. But it doesn't have to be that way. People can and should and often do make binding death benefit nominations whereby they nominate a party to receive the superannuation, where they nominate a party to receive the benefits of a life insurance policy. In those circumstances, those payments or those benefits do not go into the estate. They go directly to the nominated beneficiary or person at the end of the day. Is there a right and wrong answer? Yes, no, sorry, there isn't, because again, every case is different as far as it's concerned. As a general overview, most spouses will leave the superannuation to each other. But once you've got adult children, although you can leave superannuation death benefits to certain people, for example, adult children and people that are financially dependent on you, and even people that are in an interdependency relationship with you, if you leave it in your estate, the advantage of that is that you can ultimately control how your children, generally if it's going down through the family, how they will receive that inheritance, preferably again in a tax effective and in an asset protection basis via a testamentary trust, which I'll touch on now. The downside with leaving it to your estate is that it then becomes subjected to a potential claim under the Inheritance Act legislation. And again, we're all aware of, and there are horror stories by the day, about claims that have been made on estates. And again, the fear for all of us now is that we do not want our estates to be dissipated amongst claims in relation to Inheritance Act. The two biggest growth areas in law are family law and Inheritance Act claims. And it's just because, the second part of it is just because people's estates are getting bigger and bigger with superannuation and the value of properties and other bits and pieces. But unfortunately, there is this sense of entitlement from the next generation, for whatever reason, that they've got an expectation that they're going to get an inheritance from all of us when we pass on at the end of the day. And unfortunately as well, it's fueled by my profession, because there's a lot of people in my profession that are now running these cases on a contingency basis, so contingency fee basis. And in essence what they're doing is that they are looking to see what's in the estate, and if there's a big pot of gold, they'll generally run with the client and not charge the outrageous fees that would be normally chargeable in a Supreme Court litigation, because that's where it happens in the Supreme Court. But they will rape and pillage at the end of the day, because if they're successful, they win big time at the end of the day. What are the considerations that you normally think of in a standard will? First thing is the appointment of an executor. Is there a right and wrong answer? No, there's not. Generally try and keep it simple. In most cases, if we've got a family arrangement, keep it between the spouses, because generally you will know your affairs better than anybody else. You can always go and get professional help, whether it be from a lawyer, financial planner, an accountant, or whatever. But generally, within the family would know the affairs better than anybody else. Having said that, it's not a privilege to be an executor. It's got legal, tax, accounting, and importantly, it's often got a lot of family-related issues which surface after the person's gone. I hear it again on a daily basis from people saying, and the question that I ask, how's the family? Do they get on? And the parents say, absolutely. They're all good. Very seldom will a parent say that there's friction within the family. But the problem is, as soon as that parent's gone and there's $1 on the table, the gloves come on and the lawyers come into the game and it all escalates. So in the appointment of an executor, think carefully. If you are going to ask a family friend or even a child, speak to them first, because they may not want to. So you also need to consider, are there any special bequests under a will? And a special bequest could be as simple as, look, I've got that painting over there and one of my children has said they would really like to get that. If you do not specify that in your will, there is no guarantee that that painting will end up going to that child or that organisation or that beneficiary. So think about that. You can leave a list, and a list may refer to things like jewellery and personal effects from that perspective, but just be warned that if it's not specifically dealt with, there is no guarantee that that's where it's going to go at the end of the day. You need to also cover control of trusts. I mentioned earlier on, if there is a family trust, the trust will survive your passing. But what you want to make certain of is that whoever takes control of that family trust, we're not talking superannuation now, we're talking a family trust, that whoever takes control is the right person. Again, normally if there's a surviving spouse, it'll be the surviving spouse. If it's going to go to the next generation and there's children, and people are thinking that, look, the children will get on well, they'll sort things out amongst themselves. The parents might think that we want to leave everything equally amongst the children. But there are, again, some real horror stories, and there was a huge one in Sydney going back a few years, where an elderly man had substantial assets in Sydney, property on the waterfront. Most of it was held in his family trust. He had 2 children, a daughter and a son. The daughter was the eldest one. He thought the children got on well. He left control of the trust to his daughter on the strict understanding he thought that she would do the right thing by her brother and that she would split the trust and the assets with her brother. But he didn't document that. He just handed her the keys to the car. And guess what? Brother and sister didn't get on too well. It wasn't evident to the father. His wife had previously died. What then happened was that the daughter got the keys to the car, the keys to the trust, and she just said, thank you, I'll take all of that, okay? And the son said, but, what are you doing? He took it up through all the courts, and the court said, hold on. The father was an intelligent man. He knew that if I left one set of car keys to one child, there was a possibility that that child could have just said, I'm not going to actually provide for my sibling. So in family situations with trusts, if there are multiple children, don't assume that they will do the right thing. It may mean that you've got a combination of children, which doesn't always work, or you involve a professional person in there to make sure that your wishes are given effect to. So it comes back to, can you control from the grave? Yes, you can to a degree, provided there's appropriate documentation in place. How do you deal with the balance of your estate? Again, normally, keeping it simple, surviving spouse would generally go to the surviving spouse, possibly through a testamentary trust, and possibly not, and then down to the children. And most people will follow the classic bloodline situation, so husband, wife leave to each other, they leave to their children, and then they leave down the tree to the grandchildren going forward. How can you pass assets? Simply and through a testamentary trust are the 2 basic ways. The simple distribution, and that would be generally for a smaller estate, might say, look, I die, I've got 2 children, my estate comprises $300,000, very simple estate, I just leave it to the children equally, so each child gets $150,000 at the end of the day. Can that work? Absolutely, no problem with that. But again, you need to look at the circumstances of the children. If one of the children is in a bad relationship or has got issues with drugs or alcohol, or is in a high-risk profession, you do not want to leave an inheritance to a child outright, because that is all going to be subjected to risk and potential claim, and it happens. The alternative, and very topical and very, very good way to go, is to utilise a testamentary trust or testamentary trusts. What is a testamentary trust? It's a trust which is created in a person's will, and it says, in simple terms, that that child or that category of children will inherit through a trust which they may control themselves, depending on their circumstances, or it may be controlled by them and others to protect them in the long term. The major benefit of a testamentary trust is twofold. One is the tax benefits, and secondly is asset protection issues which go with it. If you distribute from a testamentary trust as opposed to from a normal family trust, you get the full tax thresholds that apply. So currently, the first $18,200 is tax-free. So if you've got a child who in turn has got some of their own children, and those children are young, still dependent on their parents, under the age of 18 years, and you leave the inheritance to that child by way of a testamentary trust, they can distribute the income to their children. So in my example, one child, 2 grandchildren who are both still dependents, that child would then get the first $36,400 tax-free. And then it goes up in the brackets after that. And that may be a substantial benefit for that child, because contra that, if the inheritance just goes straight through to the child, they get the good, so they get the inheritance, thanks very much. But once they start investing that money, that'll be taxed in their hands and in their hands alone. So if they're already in a high tax bracket, that there is just going to take them even further. So Canberra is just going to be rubbing their hands in that situation, whereas a testamentary trust enables them to split income in a tax-effective manner, but also from an asset protection perspective, which is a great way to go as well. If you look at society now and what's happening, unfortunately, with relationships and stuff like that, I mean, the stats are pretty close to 1 in every 3 relationships is guaranteed to fail. 1 in 3 will definitely fail. 2 out of 3 is a fair chance that they're going to fail, and 1 in 3 is actually safe. Those are not good odds at the end of the day. It's great for family lawyers, but not for anybody else out there. So again, leaving inheritances to children, ultimately, if that child is actually in not a good relationship, potentially half of that inheritance may be lost overnight through the family courts. All right. That covers firstly from the will perspective, and I'm just going to go through some other related documentation which goes with this. So the will covers what's going to happen to your assets and those related assets which I spoke about after your passing. So it's made now, whilst you have the capacity, to actually make sure that your loved ones and those that you want to receive and those that you don't want to receive are excluded, will get what you've earned and what you've worked damn hard for through in your lifetime to get. We've also got to look at what's going to happen before we die. So this covers those other documents which I said we can make decisions now, and this is part of the estate planning. And those are enduring powers of attorney, enduring powers of guardianship, and in advanced health directives. And we should all be thinking about those documents as well. An enduring power of attorney covers financial and property related matters only. In simple terms, it says, if I, before I die, through accident or illness, lose my ability to manage and control my financial and property affairs, so anything to do with money, whether they be investments with David, whether they be money sitting in a bank account, whether they be dealing with Western Power on a power bill, it's something to do with money, and anything to do with property, which is real estate and stuff like that. The enduring power of attorney will cover that. In its simplest form, if you've got a husband and wife situation, they will generally appoint each other to say that if I can't deal with it, I know that my wife can, and vice versa. But you should always have a fallback. What happens, or if you're single, who do you appoint? It's an incredibly powerful document. It's a document that you need to think about very carefully, because again, there are horror stories where people have just got it completely wrong. They thought that they trusted the person, they've given them control, and if it's a widely drafted enduring power of attorney, essentially that person could walk into the person's bank and actually open their bank accounts and just fleece them overnight. So you can actually have safeguards, and the safeguards can be is that you can have two. You can appoint 2 primary, and a maximum of 2 primary and a maximum of 2 substitute attorneys. And you can appoint them either jointly or jointly and separately. If they're appointed jointly, the advantage of that is that you've got a left hand and a right hand. And the left hand cannot act without the right hand. So if somebody has to go to the bank to draw money, the left hand and the right hand have to go to the bank. The problem though with that appointment is that if the left hand is available and the right hand is not, the left hand cannot act. So if the second appointee dies, that appointment falls because it was a joint appointment. If the right hand is traveling overseas and can't be contacted when something needs to happen, the left hand cannot act. So that's why it is generally better, if you're going to appoint 2, to appoint them jointly and separately, which means that either one or both can act. But it carries risks. and it's a document that needs to be given very, very careful thought to as to who you appoint. And just because it's family doesn't mean it's right, because probably the biggest single abuse is from family, unfortunately, but that's where it's going. So as I said, that covers financial and property only. We also need to think about an enduring power of guardianship. That covers personal, lifestyle, and treatment decisions if you lose your ability to make those decisions. So critical from the point of view of an enduring power of guardianship, it only commences if basically you are no longer capable of making reasonable judgments and decisions in relation to your personal, lifestyle, and treatment-related decisions. I just want to jump back to an enduring power of attorney. An enduring power of attorney can be effective immediately. So even while you've still got the full legal capacity, you can still appoint somebody to be your attorney. So practically, if I appointed my wife, and in a week's time I get a bad dose of the flu and I just can't get down to the bank to do something, even though I've still got full legal capacity, she could go to the bank armed with that enduring power of attorney. Even if the bank account is only in my name only, the bank would have to deal with my wife because she's got the authority to deal with it. If it's not effective immediately, it will only be effective on when there is an order, which is a medical decision that I no longer have legal capacity. That becomes more cumbersome, but sometimes it's a safeguard as far as people are concerned, is that they want to retain complete control of their financial and property affairs until they are medically incapable of dealing. So, with an enduring power of guardianship, it only kicks in when a person is no longer medically capable of making those decisions. So as I said, it covers personal, lifestyle, and treatment-related decisions. It can be as narrow or as wide as you want it to make it at the end of the day. Similar to an enduring power of attorney, you can appoint a maximum of 2 primary enduring guardians, but they have to act jointly. So you can't have them acting jointly and separately like an enduring power of attorney. If you appoint 2, you've got a left hand and a right hand. And you can appoint a maximum of 2 substitute enduring guardians as well. The last document is the Advanced Health Directive. That relates to treatment only, and that's a high water mark as far as any treatment-related decisions are concerned. You can make decisions now about the treatment that you want or don't want to receive in certain circumstances. It's not euthanasia, all right? It's got nothing to do with Dr. Philip Nishke, who was the euthanasia doctor. It's got nothing to do with what's happening in Victoria at this point in time, which has just gone through their parliament. They've now got euthanasia legislation. It is highly probable that our state will get euthanasia legislation, but it's some way off at this point in time. So in a nutshell, what is an Advanced Health Directive? It says that if I ever get to a stage in life when I'm brain dead, or I've got an incurable disease, you might then say, look, I don't want certain treatment. I want to be able to die without having artificial means keeping me alive. So machines to keep you alive, if you are essentially brain dead, if there is no prospect that you will ever have a reasonable prospect of life, that you will recover, you can say, you let me go. You can administer drugs, you can operate for pain relief and dignity, but you do not want your life to be preserved by artificial means for a protracted period of time. So in its general terms, that's what it covers. It can be quite specific. So if people have got certain ailments or diseases, they can say, look, my decisions in regards to the Advanced Health Directive are relative to these issues and these issues only. So if I have got cancer and if it ever comes to the stage when they say you've got to go, it's recommended that you go for chemo, you can say, I don't want chemo, okay? And you then understand that that may have the effect of shortening your life, but it's your decision. So all of us as adults, provided we've still got the capacity, we can make that decision. That document would only kick in again once you've lost that ability to make that decision. So any one of us goes to the doctor tomorrow and a doctor recommends to do whatever treatment they may choose to recommend to deal with your ailment, you will make that decision as long as you've got the ability to understand and to communicate your response back to the doctor. So just to wash up, very brief overview of what we're looking at. What is estate planning? It covers wills, definitely, but it also covers those other documents that I spoke about. It covers the period before a person passes. The will kicks in after death. The other documents apply to this period before death. by doing these other documents, we are exercising our choices, and we are making sure that the people that we want to look after us, make decisions for us, are the people that we trust, and that we want to be in that position to make those decisions if we are unable to do so. So there is no such thing as one size fits all. We need to think carefully about what we're doing. You need to get advice, again, from lawyers, financial planners, accountants, because everybody's circumstances are different. Key to you here in this whole scheme of things is superannuation. Okay, I touched on it briefly earlier on. Where does it go? Where does it not go? It may end up in your estate depending on what nomination you've done. And if it goes into the estate, again, is relevant to each person's personal circumstances. If you've got vulnerable beneficiaries and you wanted it to go to them in a controlled manner, then definitely bring it into the estate. But if you haven't, if they're not vulnerable, and it may well be the case that you direct the payments to them without it going into the estate. But again, every case needs to be looked at on its merits and what your personal circumstances are and how they will impact on what's going to happen. There are also tax ramifications with depending on where the superannuation goes. And I'm not going to touch on that now, but just beware that there can be quite severe ramifications if superannuation ultimately ends up with a non-superannuation dependent. So if it ends up with an adult child, our friends in Canberra stick out their grubby hands and they take a fair whack on the way through. So people think about superannuation, it's a great investment tool and stuff like that, but it is, at the end of the day, it's a death duty. So even though they abolished death duties back in 1985 when they brought in capital gains tax, there is still death duties in whatever terminology you want to call it, in the event of a person dying and leaving it to a non-dependent adult beneficiary. So that's an overview of where I am, and any questions?
With the Advanced Health Directive, I've actually got one sitting on the desk, half filled in at home. When it comes to the section of, it gives a list of probably 10 or 15 different scenarios that you could fill in.
Yep.
They're all blank. Do you know of anywhere that gives you a suggestion as to, well, what about in this scenario, perhaps listing these half a dozen, say, main scenarios where you might then want to consider what you want done? So,
yep.
For instance, in the case that I've had a stroke, this is to happen. In the case that I've had a coronary, or in the case that I've had cancer, or whatever else. But when I sort of started to look at it, I thought, well, there's 1,001 different combinations of scenarios. So is there any sort of a compressed suggestion list?
Our document, as in the West Australian document, is very, very broad from that perspective. It's almost an open canvas, which invites you to actually put to paper your specific wishes, but it doesn't give you guidance, unfortunately. The best possible way to look is that if you look at the equivalent advanced health directives from over east, certainly the Queensland and the New South Wales ones from memory are 25 pages, and they go through virtually every permutation under the sun. So if you just Google advanced health directives from the eastern states, and I think from memory it's the Queensland and the New South Wales ones are very detailed, and they go over the top, but that will address the issue that you're looking at.